But there is another rule that exists that does mean that you could have problems if you have a deathbed marriage, or indeed get married after you've made a will. So for unmarried couples or people cohabiting, if one of them dies, they are treated as unconnected individuals for tax purposes. So this has inevitably given rise to the deathbed marriage, where somebody marries somebody on their deathbed to avoid inheritance tax. And according to data obtained from the General Register Office via a Freedom of Information request in September 2025, there have been 1,612 short notice marriage applications in England and Wales in the year to the 31st of March 2025. So these are legally binding marriages which are conducted at short notice, often when one partner is terminally ill and not expected to recover. So the driver in these cases is financial, to avoid liability to inheritance tax. Now, one of the issues is that because it's such short notice, it does mean there is no time to update other legal documents, for example, which can be a problem and leave families exposed. But there is another rule that exists that does mean that you could have problems if you have a deathbed marriage, or indeed get married after you've made a will. So a key provision of what is known as the Wills Act 1837 stipulates that in England and Wales, the act of marriage or entering a civil partnership automatically revokes any pre-existing will. Public awareness of this is very limited.